Hello people, this is Avnish Tiwari, faculty, St. Peter's Law Academy, Delhi. I welcome all of you in the regime of St. Peter's. And as we know that we are doing a series on judgment writing. So today's video is also pertaining to the same issue, but I had introduced the judgment writing in the first part of this series itself. So if anyone is willing to know about the introductory part of this series, please refer to the first part of this series. So we are going to do the next part of this series, and in this next part I am going to discuss certain common points between the judgment writing in criminal cases and the judgment writing in the civil cases. I am not going to merge these two ideas, but still we need to have certain basic ideas regarding judgment writing, and those ideas are pertaining to the judgment writing in both the situations, like in criminal cases as well as civil cases. So I will make the heading, same heading, that is how to write a judgment. This is the broader issue we are dealing right now. So to start with, I must tell you that we know different qualities which a judge must be having. I talked about those qualities in the previous part, but I must tell you that when the judge is having the conceptual clarity about the law and some other subjects also, means there is no confusion at all in the mind of the judge, then that judge is going to produce a high quality of judgment, because a confused mind is going to produce a confused judgment. So there should not be any kind of confusion in the mind of the judge regarding anything. It means what I am suggesting right now is that the judgment should come first in the mind of the judge, and once the decision, the verdict, the judgment is there in the mind of the judge, it can be reduced in writing, it can be contained, it can be produced in any form, but it should come to the mind of the judge first. Why? If it doesn't come to the mind of the judge, there may be some confusion subsequently. The clarity will be missing. And we know that the quality of the judgment is directly proportional to the quality of the judge. Okay, these aspects are already dealt with, but I will start certain common points, certain common conceptual points with respect to judgment writing in criminal and civil cases. This is the broader head, and this is the subheading of this broader heading. So what are those points? What are those conceptual points I want to bring to your notice? I'll write them one by one. So the first thing is that we should know that when a civil trial is going on in a court, sometimes you will see that when the court is satisfied that parties are not at issue at all, in the first hearing itself, the court will pronounce the judgment. There is no further proceeding required in that situation. Means the stage of the suit is very important. And sometimes you will see that when the suit is being tried in the court of law, the trial goes for a very, very long time. Both the parties will come when the dates will be fixed by the court. They will bring their documentary evidences, they will bring their witnesses. Witnesses will be examined as per the Indian Evidence Act. Means this whole procedure will go on, and ultimately the judgment will be pronounced after a very long time. It means sometimes in the very first hearing itself the judgment was pronounced, but in a different situation the judgment was pronounced after a very long trial. Right. And sometimes you will see that the judgment was pronounced by the court when the date was fixed by the court for the hearing, and the plaintiff was present in the court, but the defendant was absent. So in that situation also the court will proceed ex parte. Ex parte means on the side of one party only, means only the plaintiff is present in the court and defendant is absent. And if the defendant is absent, the rule says that the court will proceed ex parte, means without hearing the defendant. And if the court finds that yes, judgment may be pronounced, the court may pronounce a judgment even without the defendant, and such a judgment is known as ex parte judgment. It means in a situation when we saw that in the very first hearing judgment was pronounced, in the next situation we can easily see that a judgment is being pronounced when the defendant is absent. Similarly, there is a judgment which was pronounced after hearing the case for a very long time. Means we can see that there are different stages in a suit, and at those different stages judgments are being pronounced. Means we need to locate the stage of the suit at which the judgment is being pronounced. So I will make the heading, although we know that we are doing the judgment writing, but you can clearly notice that my inclination is towards the civil judgment right now, because I will bring the criminal cases later on after doing the judgment writing in civil cases. So what I am trying to bring to your notice right now is to understand the theoretical meaning of the word judgment is a different thing. But when it comes to the practice, the judgment is something different. The structure, the content, the format, etc. These dimensions will be discussed when we will come to the practical aspect of judgment. Because in theory, when you go through section 2 clause 9 of the CPC, there is a simple definition of judgment, but that simple definition is not going to give you the whole picture of the judgment. For that, you will have to refer to different other provisions, like you will have to refer to order 20 of the CPC, you will have to refer to section 33 of the CPC, etc. But I am not teaching you the whole CPC right now. My focus is to understand that yes, judgment writing is done at different stages of the suit. Means when we are talking about different stages, the natural realization is that we are going to understand the idea of judgment in terms of practice and not in terms of exact theory. Right. So what are these common points? Number one is facts. Whether the case is a criminal case, because I have given you the heading that these points are common in civil cases as well as in criminal cases. Let's see. The first point about writing the judgment is first point. It is the facts. Means the court will write the facts of the case in brief. it doesn't mean that you are going to leave the important facts. No. You are going to present the facts of the case in a very concise manner. This is your duty as a judge. It means how the judge will come to know about the facts of the case. In a civil case, the plaintiff files the plaint and the plaint contains the facts of the case. So, through the pleadings of the parties, the court will come to know about the facts of the case. And in criminal cases, the magistrate will come to know about the facts of the case when the police report will be filed after investigation. Right. So, police report is something, it is a document which is presented by the police after completing the investigation under the CPC. And if the police report is being filed and it is in the form of a charge sheet, that charge sheet is going to give the facts and the magistrate will come to know about the facts of that case with the help of that charge sheet. Because the police report may be in the form of a charge sheet. Although we know there is a difference, the generic concept is the police report and charge sheet is a kind of police report. And I will bring these differences when I will bring the judgment writing under the criminal law. Is what is police report, what is charge sheet, what is closure report, what is final report. These expressions will be dealt with under the CRPC. So, we do not need to refer to those things right now. But yes, this much information that the judge or the magistrate will come to know about the facts of the case with the help of pleadings in the civil cases and with the help of charge sheet in the criminal cases. And after knowing the facts of the case, the judge is going to make the brief statement of the facts. This will be the first step when the judge is going to write the judgment. And what will be the next step? Judgment writing has begun and the judge has this duty that he will write the facts in brief. This will be the first step of judgment writing. And how he will come to know about the facts, I told you. And after that, there will be evidence. So, what are the evidences which were produced by the parties? The evidence may be documentary, the evidence may be oral also. Means, if the witnesses were called by the parties, they will testify in an verbal manner and we call it as oral evidence. When the witness is going in the court and he is making a statement, means he is making his testimony, that statement of the witness is called the oral evidence. So, evidence may be oral or it may be documentary. So, the court will the court will record about the evidence, means what evidence was produced by which party. This will be written after writing the facts in brief. Got it? And what will be the third step the judge will do? Okay, parties are there, facts will be of course presented by the parties. So, the judge has written the facts in brief, step 1. Step 2, what were the evidences produced by different parties, number 2. And the third stage is that after getting the evidences in the court of law, it is the duty of the court to marshal. There is one word called marshal. We call it marshalling. Marshalling and appreciation. appreciation of the evidence. Marshalling means to arrange or to combine. And in Hindi, this marshalling is known as kram bandhan, to sequence, means to make the proper sequence of the evidences produced in the court is called marshalling. So, the court has written about the facts, and after that the court has written about the evidences produced by the parties, and after that the court is arranging those evidences, means which evidence was recorded first, which evidence was recorded later on, means the whole sequence will be mentioned by the judge. This sequencing is called marshalling. And after making the perfect and the proper sequence of the evidences produced in the court will try to evaluate those evidences, and that evaluation of the evidence is known as appreciation of the evidence. So, this is the third stage which the judge is going to do in the judgment writing, and it is happening on both the sides, in criminal cases as well as in civil cases. And I told you the meaning of marshalling. And what will be the next step after this? Fourth one. And now the judicial mind of the judge is coming to the picture after this. Although he is applying his judicial mind, there is no doubt about it, because he is a magistrate or he is a judge. But he is entering into the depth of the case. Now the time has come when the judge is thinking about what law should be applied in this particular case. The fourth stage is reference to the applicable laws, means the judge is going to refer to different provisions of different maybe statutes, regulations, ordinances, or whatever it is. Means references to the applicable laws, means what laws are to be applied in this particular case. Those laws will be decided by the court, and those laws, these applicable laws, may be some provisions of a particular statute, a particular act, and sometimes that law may be a judgment by the Supreme Court, and it may be, in a particular situation, a judgment pronounced by a High Court. So, those case laws will also be referred by the judge or the magistrate. Means this reference to applicable laws goes to the statutory laws, means different legislations, as well as different judgments also. This is the fourth stage. And after that, if the law is being applied by the court will reach up to the level where he has started to think about the outcome of the case. Right. So, now time has come to the findings of the judge or the magistrate. Findings. The court will write about its findings on different issues or different points of determination. And we know that in civil cases, when the pleadings are made by the parties, the court frames the issues. Issues are framed in the civil proceedings, and in the trial of that civil case, the court comes to answer those issues framed by itself. But in criminal cases, charges are framed by the court, and the trial goes on, and after the trial the court comes up with its findings on those points of determination. So those things are, little things, not little things, but deep things basically. But we are talking about the broader picture of the judgment writing in the first go, and these are the broader categories of things which are being presented by the judge or the magistrate in the judgment. Means the findings are there, means the finding will be on each issues in the civil case. If 3 or 4 issues were framed by the judge in a particular case, the judge will pronounce its findings on each of those issues. And we know once the court is going to give its findings, the court will have to give the reasoning also. Means how did he reach to such findings? What is the basis? What is the reasoning? Because we know that a reasoned decision is a principle of natural justice. If any decision is there and a reasoning is missing, that decision is not tenable. So every finding is a kind of conclusion, it is a kind of decision of the court, and the court is bound to give the reasoning of that finding or those findings. And now those findings will be formalized. Means there is a kind of formulation, although there is no straitjacket formula to write a judgment, but still we have certain guidelines under different provisions of the CPC as well as under CRPC, and with the help of those provisions we can formulate the judgment in every case. So after finding the solutions to different issues framed by the court will come up with its decision. This is the structure of the judgment. Although I will tell you that still there are deep concepts, deep dimensions of judgment writing, but the broader picture of a judgment is this. And after dealing with these common points between the criminal cases and the civil cases, now the time has come to bifurcate the judgment writing in criminal cases and the judgment writing in civil cases. Are you getting the point? So now I will tell you that after having this much idea, I will make a heading: judgment writing in civil cases. So this is our first task, to learn the judgment writing in civil cases. So I will bring this categorical judgment writing in the next part of our series. Thank you so much for being with me, and do watch our videos regularly, and I hope our videos are helping you, and the upcoming videos are also going to help you big time. Thank you so much. Please like, share and subscribe the YouTube channel of St. Peter's Law Academy, and don't forget to make your valuable comments at the same time. Thank you so much.